Okay, we're live. Chapter 8, Investigation by Subpoena. Part 3, the privilege against self-incrimination. A person subpoenaed in connection with a grand jury or any other criminal investigation has available all of the evidentiary privileges available to witnesses in general. For example, the right, at the witness's option, to refuse to provide information where the law designates that information as privileged and therefore free from compelled disclosure. In this context, clearly the most significant privilege is that guaranteed by the Fifth Amendment of the Constitution, the privilege against compulsory self-incrimination. The Fifth Amendment states that no person shall be compelled in any criminal case to be a witness against himself. The self-incrimination clause has an extensive common law background, and it was with respect to the interpretation of this clause that Jeff Ritter once noted that a page of history is worth a volume of logic. From Ullman v. United States, 1956, concurring. Yet the court has also frequently cited the important and diverse values underlying the privilege, footnote B, and noted the need to give the privilege a construction as broad as the mischief against which it seeks to guard. Councilman v. Hitchcock, 1892. So, I'm just going to navigate down to the footnotes. Don't know why they were left out, but the other privileges that witnesses may raise as a grounding for refusing to disclose information ordinarily flow from the law of the particular jurisdiction and therefore will vary in scope from one state to another. These include such privileges as the marital privilege, protecting at least the confidential communications between spouses, the doctor-patient privilege, protecting information passed between doctor and patient that is germane to treatment or consultation, and the lawyer-client privilege, protecting, with some exceptions, communications of clients to lawyers for the purposes of legal consultation. While all of these may arise in the grand jury context, none rivals the self-incrimination privilege, either as to the frequency with which it arises or its practical significance. So that comes after compulsory self-incrimination, I guess, as a right, but the footnote B, which came after the privilege, the most frequently cited statement of those values comes from Justice Goldberg's opinion for the court in Murphy v. Waterfront Commission, 1964, a case discussed infra in the Castigar opinion. That opinion stated, the privilege against self-incrimination reflects many of our fundamental values and most noble aspirations, our willingness to subject those suspected of crime to the cruel trilemma of self-accusation, perjury, and contempt. Our preference for incriminating statements will be elicited by inhumane treatment and abuses. Our senses of fair play, which dictate the fair state and individual balance by requiring the government to leave the individual alone until good cause is shown for disturbing him, and by requiring the government in its contest with the individual to shoulder an entire load. Our respect for the inviolability of human personality and the right of each individual to private enclave where he may lead a private life. Our distrust of self-deprecatory statements and our realization that the privilege, while sometimes a shelter to the guilty, is often a protection to the innocent. So I'm going to write down a word I just seen for the first time, trilemma. All right. Let's go on in this introductory paragraph. The Fifth Amendment prohibits compelling a person to be a witness against himself in any criminal case. From Councilman v. Hitchcock, Supra, the court not only held that the privilege available to the grand jury witness must but established its availability to witnesses in proceedings totally unrelated to the criminal process. The Fifth Amendment, it concluded, applies to a witness in any proceeding who is compelled to give testimony of potential use against him in a subsequent criminal prosecution. The key is not where the compulsion of testimony occurs, but where the compelled testimony might be used. Of course, the compelled testimony must have an incriminating potential, and the concept of potential incrimination is not without limits. The court has noted that the threat of subsequent incriminatory use of compelled testimony must be real and appreciable, not imaginary and unsubstantial. Moreover, the witness's assertion of the privilege is not conclusive on this issue. Following the witness's assertion of the privilege, it is for the court to say whether his silence is justified and to require him to answer if it clearly appears to the court that he is mistaken. Hoffman versus United States, 1951. However, since the witness asserting the privilege cannot be required to explain his testimony, answer if it clearly appears to the court that he is mistaken. Hoffman, however, since the witness asserting the privilege cannot be required to explain his testimony would be and why it might be incriminatory, the court must sustain the claim of privilege if it is evident from the implications of the question in the setting in which it is asked. That a responsive answer could possibly be incriminating. Moreover, incrimination does not require answers that would in themselves support a conviction. It is sufficient that the answers could furnish a link in the chain of evidence needed to prosecute the claimant for a ... crime. Hoffman, Supra. A witness asserts the privilege as to the particular question, unlike the criminal defendant who may simply refuse to testify, considering the incriminatory potential of a truthful response to that question. Rogers versus United States, 1951. Concluded that once the witness answers and provides incriminating information regarding a particular offense, the witness cannot resort to the privilege to refuse to answer additional questions where the responses would be incriminating only in providing further incriminating details concerning that offense. To uphold such a claim of the privilege, the court noted, would open the way to distortion of facts by permitting a witness to select any stopping point in her testimony. Of course, before a witness can decide whether to exercise the privilege, the witness must be aware of the availability of the privilege. Traditionally, witnesses in civil, criminal, and administrative proceedings are not informed upon taking the oath that they have the right to exercise this privilege. In Miranda versus Arizona, the Supreme Court extended the privilege to the person subjected to custodial interrogation and insisted that such a person be informed of his right to remain silent through the Miranda warnings. Not surprisingly, the argument was in advance that the similar self-incrimination warnings must be provided the grand jury witness, at least where the witness is a person who may be viewed as the target of a grand jury investigation. A related contention was that such a target witness must be informed of his right to the assistance of counsel and must be provided appointed counsel if indigent. The first case in this section, Mandujanu, considered both of these issues but provided the majority resolution. So those issues again: the assistance of counsel and the warnings, self-incrimination warnings. Mandujanu considered both the issues but provided no majority opinion resolution. Although Mandujanu was decided in 1976, the court has not returned to either issue. Following Mandugianu, the Justice Department issued the Internal Guidance on Federal Grand Jury Practice, which requires prosecutors to give the following notification to any grand jury witness whose conduct is within the scope of the grand jury investigation. 1, that the witness may refuse to answer any question if a truthful answer to the question would tend to incriminate him, and 2, that anything that the witness does say may be used against him, and 3, that the grand jury will permit a witness a reasonable opportunity to step outside of the grand jury room to consult a counsel if he desires. I feel like that's part of a test or analysis or rule or something. Anywho, warnings related to the self-incrimination privilege are commonly used in state grand jury proceedings as well. As to consulting with counsel, most states follow the federal practice, but a fair number of the states allow a witness to be assisted by counsel located within the grand jury room, and several of these provide for appointment of counsel at the state's expense where the witness is indigent. The second case, Castigar, considers the important practice of providing to a witness grants of immunity that precludes reliance on the privilege. That's what it stands for. So that's generally the holding. The federal immunity provision upheld in Castigar became a model for many state immunity provisions, although a substantial majority continue to provide the transactional immunity that prevailed prior to the adoption of the statute. The last 2 cases, Fisher and Hubble, returned to the issue raised in Boyd, and availability of the self-incrimination privilege in responding to a subpoena ducis tectum requiring production of documents. Boyd here had a more lasting influence than it did in the application of the Fourth Amendment to the subpoena ducis tectum. Yet, here as well, a series of cases prior to Fisher had limited its impact. It doesn't really say what Boyd stands for, and we skip that case. Apparently it was tailored by the next 2 cases before Fisher. So, in particular, one line of cases had held that the privilege against self-incrimination did not imply the compelled production of documents belonging to a corporation or similar entity such as a partnership. Thus, the court notes in Fisher... That was one line of cases. Thus, the court in Fisher, A.E., Boyd and Sons, a partnership, would no longer have the privilege available to it to contest the compelled production of a document. Another line of post-Boyd rulings had held that the compelled production of identification evidence, example, blood samples or handwriting exemplars, whether compelled by subpoena ducis tectum or otherwise, was not subject to the self-incrimination privilege. Privilege, the court noted, applies only to the compelled production of testimony, i.e. communications, though its protection extended beyond compelling words from a person's own lips, reaching communications in whatever form they may take. It did not encompass compulsion, which makes a person the source of real or physical evidence. See example, Schmerber v. California, 1966. Fisher considers the extent to which the privilege applies to the compelled production of documents in light of these post-Boyd developments. Hubble applies the Fisher analysis and considers its bearing on the grant of immunity as to the compelled production of documents. So I am going to return. Well, I'm going to now proceed to United States v. Mandugianu. I'm going to note for case law purposes that there is a sort of relevance statement about Fisher and Hubble and earlier about Hestagar. And actually, we already know what Mandugiano issues are based on this introduction. So I'll read them again. Those issues were about the warnings and the right to counsel. We also know sort of that there's an analysis or a rule that's going to come out of it. Can already expect that. It's like a 3-part rule. And it's on page 601. We'll go back to it. So let's start reading the case. Justice Berger announced the judgment of the court in an opinion in which White, Powell, and Rehnquist joined. This is in 1976. This case presents the question whether the warnings called for by Miranda v. Arizona must be given to a grand jury witness who is called to testify about criminal activities in which he may have been personally involved, and whether, absent such warnings, false statements made to the grand jury must be suppressed in the prosecution for perjury based on those statements. In March of 1973, an undercover agent received information that Mandugiano was dealing in narcotics. Keeping his identity secret, the agent met Mandugiano and arranged for the purchase of heroin. Mandugiano received $650 for the purchase. Wow, that's a bunch of heroin in 1973. But returned the same night without the heroin and refunded the money. After Mandugiano failed to keep a subsequent appointment, the agent closed the investigation file and reported his contact with Mandugiano to federal prosecutors. 6 weeks later, Mandugiano was subpoenaed to testify before a special grand jury investigating the drug traffic in the local area. Before testifying, the prosecutor informed Mandugiano of his general duty to answer, his right not to answer incriminatory questions, and the possible perjury. Liability for false answers. Mandugiano was also told he could have a lawyer outside the room with whom he could consult. When asked if he had a lawyer, Mandugiano responded, "I don't have one. I don't have the money to get one." During the grand jury questioning, Mandugiano admitted that he had purchased heroin as recently as 5 months ago, but denied knowledge of the identity of any dealers except for one street corner source. He maintained this position, notwithstanding the prosecutor's suggestion that our information is that you can tell us more than you have today. Mandugiano steadfastly denied either selling or attempting to sell heroin since the time of his conviction 15 years before. He specifically disclaimed having discussed the sale of heroin with anyone during the preceding year and stated that he would not even try to purchase an ounce of heroin for $650. Wow. Okay, so this is the subpoena responses. Oh my God, ow. The very availability of the Fifth Amendment privilege to grand jury witnesses suggests that occasions will often arise when potentially incriminating questions will be asked in the ordinary source of the jury's investigation. It is in keeping with the grand jury's historic function as a shield against arbitrary accusations to call before it persons suspected of criminal activity so that the investigation can be complete. This is true whether the grand jury embarks upon an inquiry focused upon individuals suspected of wrongdoing or is directed at persons suspected of misconduct, but who may be able to provide links in a chain of evidence relating to criminal conduct of others, or is centered upon broader problems of concern to society. It is entirely appropriate, indeed imperative, to summon individuals who may be able to illuminate the shadowy precincts of corruption and crime, since the subject matter of the inquiry is crime, and often organized, systematic crime, as is true with drug traffic. It is unrealistic to assume that all the witnesses capable of providing useful information will be pristine pillars of the community, untainted by criminality. Accordingly, the witness, though possibly engaged in some criminal enterprise, can be required to answer before grand jury, so long as there is no compulsion to answer questions that are self-incriminating. The witness must invoke the privilege, however, as the Constitution does not forbid asking of criminative questions. U.S. vs. Monia in 1943. The Fifth Amendment speaks of compulsion. It does not preclude a witness from testifying voluntarily in matters which may incriminate him. If, therefore, he desires the protection of the privilege, he must claim it, or he will not be considered to have been compelled within the meaning of the amendment. He must claim his privilege. So, evoke your privilege. Compulsion, apparently, element in the Constitution and the Fifth Amendment, which I wasn't thinking there was. So, how much longer of the majority opinion do we have to get through? It's looking like about 2 full pages. Let's continue. Absent a claim. I'm just wondering where is the end of the facts and the beginning of the analysis, really. So he was subsequently indicted. He tried to suppress, but the district court sustained the motion on the grounds, and the appeals court affirmed. What does that mean? What is the result? So did he lose at the trial court? The district court sustained the motion on the grounds that a putative or virtual defendant was entitled to Miranda warnings, and they affirmed at appeal level. Because they want these warnings given. Okay, got it. So, you gotta revoke the privilege. Next, absent a claim of the privilege, the duty to give testimony remains absolute. The stage is therefore set when the question is asked if the witness interposes a privilege. The grand jury has 2 choices. If the desired testimony is of marginal value, the grand jury may pursue other avenues of inquiry. If the testimony is thought sufficiently important, the grand jury can seek a judicial determination as to the bona fide of the witness's Fifth Amendment claim, in which case the witness must satisfy the presiding judge that the claim of privilege is not a subterfuge. If, in fact, there is reasonable ground to apprehend danger to the witness from his being compelled to answer, the prosecutor must then determine whether the answer is of such overriding importance as to justify a grant of immunity to the witness. If immunity is sought by the prosecutor and granted by the presiding judge, the witness can be compelled to answer on pain of contempt, even though the testimony would implicate the witness in criminal activity. They keep referring to him as a witness, but, he's only been subpoenaed to incriminate himself. So I was, a hard time just referring to him as, a witness, and some other thing. And some other in community crime. Anyhow, he's a suspect. He's being interrogated in a grand jury setting. Let's call it what it is. In this constitutional process of securing a witness testimony, perjury simply has no place whatever. Perjured testimony is an obvious and flagrant affront to the basic concepts of judicial proceedings. Effective restraints against this type of egregious offense are therefore imperative. The power of subpoena, broad as it is, and the power of contempt for refusing to answer, drastic as that is, and even the solemnity of the oath cannot ensure truthful answers. Hence, Congress has made the giving of false answers a criminal act punishable by severe penalties. In no other way can criminal conduct be flushed into the open where the law can deal with it. Similarly, our cases have consistently, indeed without exception, allowed sanctions for false statements or perjury. They have done so even in instances where the perjurer complained that the government exceeded its constitutional powers in making the inquiry. See Bryson v. United States, 1969. In Bryson, a union officer was required by federal labor law to file an affidavit averring that he was not a communist. The affidavit was false and material statements. In a collateral attack on his conviction, Bryson argued that since the statute required him either to incriminate himself or lie, he would not lawfully be imprisoned for failure to comply. The court rejected the contention. It cannot be thought that, as a general principle of our law, a citizen has a privilege to answer fraudulently a question that the government should not have asked. Our legal system provides methods for challenging the government's right to ask questions. Lying is not one of them. In this case, the Court of Appeals required the suppression of the perjured testimony to testimony given by the respondent as a witness under oath, lawfully summoned before an investigative grand jury had questioned about matters directly related to the grand jury's inquiry. The court reached this result because the prosecutor failed to give Miranda warnings at the outset of Mandugiano's interrogation. Those warnings were required in the Court of Appeals' view because Mandugiano was a virtual or putative defendant, that is. The prosecutor had specific information concerning Mandugiano's participation in an attempted sale of heroin, and the focus of the grand jury interrogation, as evidenced by the prosecutor's questions, centered on Mandugiano's involvement in narcotics traffic. Yeah, that's kind of what I was saying. I pointed that out, but what does it mean? In this case, the Court of Appeals required the suppression, so it's kind of like they're holding. Because he was a virtual putative defendant. There you go. Okay, now I understand what that means. The court's analysis premised on the prosecutor's failure to give Miranda warnings erroneously applied the standards fashioned by this court in Miranda. The warnings were aimed at the evils seen by the court as endemic to police interrogation of a person in custody. Miranda addressed extrajudicial confessions or admissions procured in a hostile, unfamiliar environment which lacked procedural safeguards. The decision expressly rested on the privilege against compulsory self-incrimination. The prescribed warning sought to negate the compulsion thought to be inherent in police station interrogation, but the Miranda court simply did not perceive judicial inquiries and custodial interrogation as equivalents. The compulsion to speak in the isolated setting of the police station may well be greater than in courts or other official investigations, where there are often impartial observers to guard against intimidation or trickery. The court thus recognized that many official investigations, such as grand jury questioning, take place in a setting wholly different from custodial police interrogation. Indeed, the court's opinion in Miranda reveals a focus on what was seen by the court as police coercion, derived from factual studies relating to police violence in the third degree, physical brutality, beating, hanging, whipping, or sustained or protracted questioning incommunicado in order to extort confessions. To extend these concepts to questioning before a grand jury inquiring into criminal activity under the guidance of a judge is an extravagant expansion never remotely contemplated by this court in Miranda. The dynamics of constitutional interpretation do not compel constant extension of every doctrine announced by the court. The warnings volunteered by the prosecutor to respondent in this case were more than sufficient to inform him of his rights and his responsibilities and particularly of the consequences of perjury. To extend the concepts of Miranda as contemplated by the Court of Appeals would require that the witness be told that there was an absolute right to silence, and obviously any such warning would be incorrect, for there is no right before a grand jury. Under Miranda, a person in police custody has, of course, the absolute right to decline and answer any questions incriminating or innocuous, whereas a grand jury witness, on the contrary, has an absolute duty to answer all questions subject only to the Fifth Amendment claim. And even when a grand jury witness asserts the privilege, questioning need not cease except as to the particular subject to which the privilege has been addressed. Other lines of inquiry may properly be pursued. Respondent was also informed that if he desired, he could have the assistance of counsel. That counsel could not be inside the grand jury room. The statement was plainly a correct recital of the law. No criminal proceeding has been instituted against respondents, hence the Sixth Amendment right of counsel had not come into play. Which is why this is so wrong. The witness before a grand jury cannot insist as a matter of constitutional right on being represented by his counsel. In Re Grobin, 1957. Under settled principles, the witness may not insist upon the presence of his attorney in the grand jury room. Federal Rules of Criminal Procedure 6D. Respondent was free at every stage to interpose his constitutional privilege against self-incrimination, but perjury was not a permissible option. The judgment of the Court of Appeals is therefore reversed. So, you then see, and I'm just going to say, this was a plurality opinion according to the introduction. So, what Berger gave the opinion, White agreed, as well as, I want to say Frankfurter, but let me just check. No, Powell and Rehnquist. So here, Stevens and Brennan and Marshall. Okay, Stevens took no part in consideration decision of this case. Brennan and Marshall concur. Which makes that a total of 5. So this appears to have be a majority opinion. I concur in the result reached by the court, for even when the privilege against self-incrimination permits an individual to refuse to answer questions asked by the government, if false answers are given, the individual may be prosecuted for making false statements. Mackey v. United States, 1971, Brennan concurring. Our legal system provides methods for challenging the government's right to ask questions. Lying is not one of them. Bryson v. United States. Further, the record satisfies me that the respondent's false answers were not induced by government tactics or procedures so inherently unfair under the circumstances as to constitute a prosecution for perjury, a violation of the Due Process Clause of the Fifth Amendment. However, 2 aspects of the plurality opinion for the court suggest a denigration of the privilege against the self-incrimination and the right to the assistance of counsel, with which I do not agree. The plurality opinion mechanically quotes United States v. Monia for the proposition that the Fifth Amendment speaks of compulsion. It does not preclude a witness from testifying voluntarily in manners which may incriminate him. Therefore, he desires a protection of the privilege, he must claim it, or he must not be considered to have been compelled within the meaning of the amendment. In my view, the conception of the Fifth Amendment privilege expressed in Monia dictum is explainable only by reference to the facts and circumstances of the only case cited in support of Monia. In case, Justice Brennan explained, in which the potential for incrimination could not be evaluated without a claim by the witness because that potential was not readily apparent from the context of the question. It is only in a context where this lack of notice on the part of government rationale and significance that we can possibly justify a dictum with a witness testifying under judicial compulsion. That classic form of compulsion to which the Fifth Amendment is centrally addressed must claim the privilege or else, without any further analysis, he will not be considered to have been compelled within the meaning of the amendment. The use of the prosecutors of the tactic of calling a putative defendant before a grand jury and interrogating him regarding transactions and events for which he is about to be indicted is, in the absence of an intentional relinquishment or abandonment of his known privilege against compulsory self-incrimination, a blatant subversion of the fundamental adversary principle that the state established its case not by interrogation of the accused, even under judicial safeguards, but by evidence independently secured through skillful investigation. Such tactics by prosecutors are exemplars of the very evil sought to be prevented by the enshrinement of the Fifth Amendment privilege in the Constitution. Thus, I would hold that in the absence of an intentional and intelligent waiver by the individual of his known right to be free from compulsory self-incrimination, the government may not call before a grand jury one whom it has probable cause, as measured by an objective standard, to suspect committed a crime, and by the judicial compulsion compel him to testify with regard to that crime. In the absence of such a waiver, the Fifth Amendment requires that any testimony obtained in this fashion be unavailable to the court for use at trial. Such a waiver could readily be demonstrated by proof that the individual was warned prior to questioning that he is currently subject to possible criminal prosecution for the commission of a stated crime, and he has a constitutional right to refuse to answer any and all questions that may tend to incriminate him, and by record evidence that the individual understood the nature of his situation and privilege prior to giving testimony. The second and also disturbing facet of the plurality opinion today is its statement that no criminal proceedings have been instituted against respondent. Hence, the Sixth Amendment right to counsel had not come into play. It will not do simply to cite, as does a plurality opinion, Kirby versus Illinois, for the proposition. Kirby's premise, so fundamental that it is noted at the outset, was that the constitutional privilege against compulsory self-incrimination is in no way implicated here. In sharp contrast, the privilege against compulsory self-incrimination is inextricably involved in this case, since a putative defendant is called and interrogated before a grand jury. Clearly, in a case, a defendant is faced with the prosecutorial forces of organized society and immersed in the intricacies of substantive and procedural criminal law. It is true that dictum in Henry Groban denied there is any constitutional right of a witness to be represented by counsel when testifying before a grand jury. But neither Groban nor any other case in this court has squarely presented the question. Moreover, more recent decisions, i.e., Miranda versus Arizona and Escobedo versus Illinois, recognizing substantive affinity and therefore the coextensiveness of certain circumstances of the right to counsel and the privilege against compulsory self-incrimination, have led many to question the continuing vitality of such older dicta, given the inherent danger of subversion of the adversary system in the case of a putative defendant called to testify before a grand jury, and the peculiarly critical role of the Fifth Amendment privilege as the bulwark against such abuse. It is plainly obvious that some guidance by counsel is required. It may be that a putative defendant's Fifth Amendment privilege will be adequately preserved by a procedure whereby, in addition to warnings, he is told that he has a right to consult with an attorney prior to questioning, that if he cannot afford an attorney, one will be appointed to him, that during questioning he may have that attorney wait outside the grand jury room, and that he may at any and all times during questioning consult with the attorney prior to answering any question posed. At least if such minimal protections are present, a putative defendant could be able to consult with counsel prior to answering any question that he might in any way. The exact dimensions of the right to counsel, since the testimony obtained by the grand jury interrogation was not introduced as evidence at respondent's trial on the charge concerning which he was questioned. I read only to make plain my disagreement with the implication in the plurality opinion that constitutional rights to counsel are not involved in a grand jury proceeding, and my disagreement with the further implication that there is a right to have counsel present for consultation outside the grand jury room, but that it is not constitutionally derived, and therefore may be enjoyed only by those wealthy enough to hire a lawyer. I cannot accede to a return to the regime of squalid discrimination. Squalid. Where the justice a man gets depends on the amount of money he has. Griffin versus Illinois. If indeed there is, as the plurality opinion says, a right to have counsel present outside the door of the grand jury room, it is most assuredly, in my view, everyone's right, regardless of economic circumstance. Now, Stewart and Blackman join concurring in the judgment, too. I'm counting like 7 people that concurred and 1 person who abstained. And more than likely there's another occurrence. Concurrence. The Fifth Amendment privilege against compulsory self-incrimination provides no protection for the commission of perjury. Bryson v. United States, the respondent's grand jury testimony is relevant only to his prosecution for perjury and was not introduced in the prosecution for attempting to distribute heroin. Since this is not a case where it would possibly be argued that the perjury prosecution must be barred because of prosecutorial misconduct or prosecutorial conduct amounting to a denial of due process, I would reverse the judgment without reaching the other issues explored by the Chief Justice's opinion and by Justice Brennan in his separate opinion. Breaking before Castigar.